As a pretermitted spouse, you likely have legal rights to an estate inheritance. Here's a simple guide to help you get started in the process to get your inheritance. What is a pretermitted or omitted spouse? A pretermitted spouse simply is someone who married a decedent after his or her will or trust was created or amended. As long as there's no estate planning document created after the marriage, the spouse may file what's called a petition to determine heirship to establish the spouse's right to his or her intestate share of the decedent's estate. California Probate Code section 21610 outlines the rights of a pretermitted or omitted spouse. How do I prove I'm pretermitted? Generally, it's clear and obvious when a spouse is pretermitted. In fact, in many of these situations, the fact the spouse was omitted may not even be disputed or lead to a dispute about what the spouse is entitled to. This is because in most situations, it's simply a case of a will or trust predating the marriage and not having been updated after the marriage. If the spouse's pretermitted status is disputed, then the omitted spouse simply needs to file a petition to determine heirship with their county probate court and establish that he or she was married to the decedent after the estate plan was created. Probate litigation counsel should be contacted early to assert the spouse's rights, which can often help avoid costly and drawn-out legal proceedings. How much does a pretermitted spouse inherit? Under most state probate laws, a pretermitted or omitted spouse will receive the same amount they would have had there been no will or trust, also referred to as a statutory share or an intestate share. For example, if there are no children, the surviving spouse will take the entire estate. If there's one child, the surviving spouse will take the decedent's community property and 50% of the separate property. If there's more than one child, the surviving spouse will take the decedent's community property and 1/3 of the separate property. How do I get my inheritance as a pretermitted spouse? The first step is to consult an estate litigation attorney who can examine your claim and advise you on how best to proceed, whether that is contacting the estate administrator or trustee or proceeding straight to court. If court is the best next step, your attorney will help prepare and file in the decedent's county probate court a petition to determine heirship. This notifies the county probate court charged with overseeing the administration of the decedent's affairs, as well as the decedent's other heirs, that you are making a claim against the estate for your fair share. Filing the petition will begin the legal process and give you a mechanism to secure an amicable resolution of your claim, for example, settlement, or to secure a judgment after trial. This process should be handled in consultation with a probate lawyer to ensure the best result. It's important to consult with a probate litigation attorney as soon as you learn of the decedent's passing to ensure your claim is filed timely and before the decedent's estate is distributed to his or her other heirs. If you file your claim after the estate has already been distributed, you're going to have a harder time collecting, and it's going to take a lot longer and cost a whole lot more. What if I've been disinherited? In most states, including California, a spouse can legally disinherit their spouse, leaving them with no rights to any estate assets. If you've been disinherited, you may have a claim to contest or challenge the disinheritance. For example, if you feel you were disinherited due to the undue influence of the decedent's child or a third party like a caregiver, then you should seek counsel to ask about contesting the will or trust. These are emotional and complicated situations. If you have questions about being disinherited, please call for a free consultation. When should I contact a probate litigation attorney? Generally, the sooner you contact a probate litigation attorney, the better. Getting your rightful assets as a pretermitted spouse is much faster if everything is figured out before any estate assets are distributed. It takes longer and costs more if the pretermitted spouse's inheritance has to be dragged back or clawed back from other heirs and beneficiaries who've already received those assets. How much does a probate litigation attorney cost? While probate litigation can be expensive, many lawyers, like RMO, offer alternative fee arrangements, whether it's a contingent fee or a hybrid fee arrangement. Don't let the fear that you can't afford it deter you from taking advantage of a free consultation. Do I need a probate litigation attorney near me? We recommend finding an experienced probate litigation attorney familiar with the county probate court in the county where the decedent lived. For example, if the decedent lived in Los Angeles, we recommend working with a probate litigation attorney in Los Angeles. That Los Angeles probate litigation attorney generally will be more familiar with the Los Angeles Superior Court Probate Division than an out-of-area attorney. At RMO, we help people like you address issues like these every day. Have questions? Give us a call or shoot us an email. The consultation's always free. Thanks for watching.